and thanks for joining us for this WTTW News Special. I'm Nick Blumberg. Brandis Friedman has the evening off. Tonight, we're focusing on police discipline. The city's watchdog says police officials frequently failed to document when officers were reprimanded or suspended. And the years-long battle over police discipline makes its way to the Supreme Court. More on the potential impact. And we'll get to our focus on police discipline in just a moment. But first off tonight, Illinois Congresspeople slammed the conditions at an ICE facility in West Suburban Broadview after being allowed in for a tour. 4 Democratic representatives made an oversight visit earlier today where they reiterated charges that what's supposed to be a processing center is instead a detention facility without adequate space for detainees, including just 3 open bathrooms for dozens of people. Congresswoman Delia Ramirez called it, quote, despicable that it took months of legal battles and public pressure for lawmakers to be allowed inside.
What we walked into was a cold place of detention. And it is important for us to say that there's irrefutable evidence that ICE is holding our neighbors, including our children and pregnant women, in inhumane conditions in ICE facilities, where they're going without access to medication if they didn't bring their medication, without legal counsel because many of the people being taken don't have an attorney on retainer, or even without basic necessities.
Congresspeople had previously been turned away from the Broadview facility. Last week, a federal court affirmed that lawmakers have the right to make oversight visits at immigration detention sites. Supporters of Mayor Brandon Johnson's budget are pushing back on the rival plan that passed over the weekend, saying it bows to wealthy corporations at the expense of working people. The People's Response Network and its allies held a virtual news conference today in support of the mayor's corporate head tax proposal and likened a coalition of alderpeople that crafted the rival budget to obstructionist members of the city council during the Harold Washington administration.
This budget, first of all, is not balanced. And what they're going to do is to unleash debt collectors. And we are going to see a downgrade because that is never, and they know that, there is never a way to balance any budget. This has more holes than the potholes that we continue to see across the city of Chicago.
The mayor has called the plan passed over the weekend unbalanced and immoral, but has yet to announce whether he'll veto it. For more on what's in the budget and to see how your alderperson voted, you can visit our website. Nice try, Illinoisans, but some of those wacky license plates just aren't fit for the street. The Illinois Secretary of State's office is out with its annual list of rejected vanity and personalized license plates. Among the ones that didn't fly and that we can actually say on air are BBL, ICUP, and Badass Mom. The Secretary of State's office received more than 55,000 plate applications this year. More than 550 of them didn't make the cut. Better luck next time, drivers. Up next is the Chicago Police Department failing to document suspensions and reprimands for officers. We dig into the details right after this.
WTTW News coverage of policing and police reform is supported by the Joyce Foundation.
Police officials frequently failed to document when officers were reprimanded or suspended for wrongdoing. That's according to the city's Inspector General. The audit is the latest to raise concerns about CPD's ability to hold officers accountable for misconduct. Our Heather Sharon joins us now with the latest on that effort. So, Heather, break down this latest report for us from IG Deborah Witzburg. What did her office find?
Well, during 2016 to 2021, she found that 1/2 of all officers were reprimanded for misconduct. That was not properly documented. And in the case of suspensions, 1/3 were not properly documented. She says that's especially troubling because there can be no public trust in a police accountability system that does not properly record when officers are being disciplined.
Yeah, those are some pretty significant numbers. This audit also raised questions about what happens when officers use paid time off to serve suspensions. Why is the Inspector General concerned about that?
Well, that is allowed under department rules, but she says that sometimes when that happens, that time off does not get recorded as a suspended time off, which makes it impossible for, if that officer commits another act of misconduct, for that initial suspension to be properly incorporated into whatever discipline he or she gets in the next round. She says that is a serious problem.
How has CPD responded to Witzburg's findings?
Well, they said that basically this data is out of date, that CPD has made big strides since 2021 using a new case management system to do a better job tracking this discipline and making sure officers are properly held accountable when they're found responsible for misconduct. Inspector General Deborah Witzburg says there are big questions as to whether those changes are actually showing results.
So, this issue lies right at the heart of the effort to reform the Chicago Police Department and to implement the consent decree. Now, Mayor Brandon Johnson, for his part, has vowed to increase those efforts next year. What exactly does that look like?
Well, he says he is going to demand that CPD step up efforts to create a system that will essentially warn police brass when an officer has multiple complaints or multiple lawsuits. That system is required by the consent decree, but has yet to be rolled out citywide. And he says he's going to make CPD come back to the City Council quarterly with updates on how it's progressing.
Be very interesting to see what alders have to say about that. Heather
Indeed.
Sharon, thanks so much.
Thanks, Nick.
And you can read Heather's full story on our website. It's all at WTTW.com/news. The Illinois Supreme Court is set to weigh in next year on whether serious police misconduct cases must be heard publicly. This after the Fraternal Order of Police, the city's largest police union, appealed an earlier ruling from a lower court requiring public disciplinary hearings. The case comes as the Chicago Police Department continues to work under a consent decree monitored by a federal judge. How to handle discipline is an important part of that process as well. Joining us to discuss that and more are John Catanzara, president of the Fraternal Order of Police Chicago Lodge 7, Kyle Cooper, president of the Chicago Police Board, David Melton, an attorney with the Chicago Council of Lawyers, and Jasmine Smith, an organizer with the Chicago Alliance Against Racist and Political Repression. And we also invited the Chicago Police Department, but they declined to join us. But we thank the four of you for joining us this evening. Kyle Cooper, for folks who don't quite know what the police board does, can you give us a sort of a quick overview of its makeup and its mission?
Sure, and thanks so much for having me, Nick. I really appreciate the invite. So the Chicago Police Board has 5 main functions. One of them is hearing disciplinary cases involving the most serious cases of misconduct, so cases where the punishment could be a discharge from the CPD or a suspension for over a year. The board also has 4 other core functions. We hear appeals by applicants who are looking to become police officers who are removed from the eligibility list due to the results of a background investigation. We also hold monthly police board meetings where the superintendent and other key stakeholders attend. And we also promulgate the rules and regulations governing the Chicago Police Department, an effort we are currently undertaking to revise in 2026. So those are the core functions of the Chicago Police Board.
And who sits on the board?
The board is made up of 9 members, all of which have to be citizens who reside in the city of Chicago. The board also has to be composed of at least 2 lawyers, a community activist, a former or current law enforcement official. So the board is comprised of a panoply of different backgrounds and professional experiences, all of whom are Illinois and Chicago citizens.
John Catanzara, the system of open police board hearings has been in place for decades. Why are you looking to change it?
Well, the provision within the contract has been there since the inception of the police board. There has always been a provision that said either party can opt out of that provision within the collective bargaining agreement. All we did was exercise that option within the agreement for very specific reasons. I'll give you some quick stats here. From the preceding years to taking office, 2017 to 21, there were roughly 49 police board cases. 32 of those were recommended for termination. The police board upheld 32 of those, 66%. It gets worse though. In that same time frame, the superintendent disagreed with COPA's recommendation of termination on 17 cases. 15 of those the police board upheld as termination cases. 88% of the time, they overruled the superintendent's recommendation and still fired and upheld COPA's recommendation. That excessive percentage of it was you're a dead man walking or woman per se with your career led us to exercise that option within the contract. And I will tell you, I'm sure Kyle's going to go and say, well, those percentages are different now. Of course it is, because we exercised the option and we were granted relief in the courts who upheld that, and now they're trying to justify their viability and long-term survivability.
Well, Kyle Cooper, how about that?
Yeah, I think if you look at the hard data, especially let's talk about 2025, the police board decided 5 cases this year. In 3 of those cases, the board voted in favor of exonerating the officer accused of misconduct. In 1 of those cases, the board decided that a suspension was the appropriate amount of punishment. And in only 1 case in 2025 did the board vote to remove and discharge the officer from the Chicago Police Department. If you look at the statistics since 2021, the percentage of cases in which the officer accused of misconduct was discharged from the Chicago Police Department, it was around 22%, which is in line with the number of cases where the officer was exonerated and the number of cases where the officer was suspended. So the statistics and the stats show a story where the board is acting in good faith and taking each case on a case-by-case basis. And so those allegations of bias or there's some anti-police rhetoric, I just think are completely unfounded, and you just have to look at the numbers to see that.
Well, David Milton, how do you see it? I mean, are they calling balls and strikes?
I see John has selectively cited some statistics. The statistics he cited are from the post-Laquan McDonald era. People remember that in 2014 or 15, Laquan McDonald was shot by police officers. That shooting was unjustified. And in the wake of that shooting, the police board procedures and membership was revised to make it fairer. Before that shooting, if you look at the statistics from 1960 up to 2017, you will see that a disproportionate numbers of officers who did engage in misconduct were let off by the police board, notwithstanding contrary findings by arbitrators. So that process needed to be reformed to make it fair not only to police officers, which we want it to be, but also to the victims when they engage in misconduct. And that's what those reforms following the Laquan McDonald shooting accomplished.
You know, Jasmine Smith, CPD has long had strained relationships with some Chicago communities. Could a closed-door arbitration process, make efforts to improve those relationships more difficult?
Yes, it would. It would make it a whole lot difficult, and it's going to get a whole lot bad when it comes to community trust in the police. We've been generations of dealing with no accountability really with officers. When it comes to their misconduct, when it comes to them killing someone, they're not being charged for the crimes of that. They're getting slaps on the wrist. None of them really even being fired for killing someone's son. Like, we have so many cases that we're dealing with where the police killed a teenager or by pretextual, or pretextual stops, or, just nitpicking, like and then violating laws that's been put in place, like the do not chase. Like you chasing someone, then you shoot them, and then you're not being held accountable for like violating those type of laws. So it's just a lot when it comes to the trust with the police. If there's no accountability, and if they're trying to hide things behind closed doors, have hearings for cops behind closed doors, what is that really saying? If you don't have anything to hide, why would you want to have things your cases discussed behind closed doors?
Well, and John Catanzaro, if you're concerned about the system here being biased against police officers, could public hearings, a public process, be to your benefit so that people can witness any of that out in the open?
Well, let's tackle a couple things here because it is a little 3-on-1 dynamic. So let's start with David's point about 1960. Are we serious? We didn't have collective bargaining rights till 1981 when that provision began, number one. So again, we exercised an option within the contract, and we can talk about the Laquan McDonald post kind of police board existence. But Kyle made my argument for me. The reason that the percentages have dropped is because they're trying to justify their existence, knowing that termination for arbitration is going to be the path forward, and they are going to be forced into irrelevance at that point. And then Jasmine brought up some irrelevant and emotional arguments, which is always seems to be at the forefront of the opposition to this. We could talk all day about people not being held accountable. It's just not factual. Or talk about pretextual traffic stops. There is no prohibition on chases. You have to have a balancing test. It's a ridiculous balancing test that's excessive, but it isn't prohibited outright. So sit there and say that a shooting resulted from a foot chase or a car chase is absolutely disingenuous. It's basically given the perception to the public that is not accurate. And again, our members are simply looking at laws. You talk about laws being violated. How about the actual law that says arbitration is a private entity for all unions in this state? If the General Assembly and the City of Chicago wish to give police officers in the city the right to strike, like the teachers, we'll gladly trade that for arbitration in a heartbeat.
Well, but what we heard from the court was that, this is a long-standing practice to have these open hearings, and for good reason. Would you disagree with that?
No, because I've actually experienced these hearings, and they aren't as fair as they say they are. I can give you two simple examples, one personal, one other very notorious one. Personally, when Lori Lightfoot decided I needed to be fired because I was too much of a thorn in her side, no doubt that she had conversations with Andrea Kirsten at COPA. A year after I became president, then they moved to finally fire me for an incident that occurred, accusations, 3 years prior that COPA sat on this. And then once I'm a president for a year and too much of a pain in the behind, they decide now they need to fire me. And when we made subpoenas to have Lori Lightfoot and Andrea Kirsten testify at my police board hearing, they were denied by the hearing officer of the police board. Again, it's not a fair process. Arbitration doesn't have that obstacle. Number two, the most infamous case recently is the Eric Stillman and Adam Toledo shooting. Literally, the way it goes is the superintendent, COPA makes a recommendation, the superintendent either concurs or does not. The superintendent did not concur with firing. That means it goes to the police board. The police board randomly picks one person. Surprisingly, it was Guion Foreman, the president of the police board at the time, who was assigned randomly to make that decision. And of course, he decided that he was going to side with COPA and it was going to a full hearing. I see him a couple days later at a function, a police function, and I tore into him about it. And he told me, don't worry about it, he'll be fine. I go, what do you mean he'll be fine? You're basically telling me that you don't believe he's guilty, but you're still sending him for a full termination hearing, tormenting this kid's life even further than it's already been. But that's the recurring theme with the police board. It's not been fair. Arbitration is, and it is not totally private. You do get the arbitration award submitted to the labor board, which is a foiable result at the end of the process.
Yeah, just a couple of things to comment on Mr. Canizaro's comments. First of all, in a lot of what you just heard, you heard a lot of boogeyman and sort of like personal grievances. I can tell you, as someone who's been on the board for the last 2 years and as a president of the board, all 9 members of the board are non-biased members of the city who deeply care about not only effective policing, but accountability, and that goes both ways. It goes with respect to the officers who are accused of misconduct, but also the victims or the complainants who are the subject of the misconduct. And so to sit here and to think that there's some nefarious purposes motivating the members of the board to make their decisions, I think it's completely wrong and does a disservice to the good citizens who take time out of their day jobs to do this job. And another thing that Mr. Canizaro was talking about, I think mulls in favor of having this process be out in the open, is you can go on the police board's website or go to our hearings and see how these charges are being handled and dealt with in the public. Arbitration doesn't provide that level of transparency, and I think it does a disservice to the officers that Mr. Canizaro represents to have these officers choose a procedure or a process that shields them and the public from looking into allegations of misconduct. I think it only furthers a level of distrust that I think is sorely lacking in the city, and I just haven't heard of a good reason why, given the option of arbitration or not, that Mr. Canizaro is advocating for a position that takes these disciplinary proceedings out from the public and into the dark.
Well, and David Melton, you've been involved in this legal fight over public hearings versus arbitration. What kind of precedent is there in terms of having these hearings publicly?
Well, the police board was established around 1960 in order to reform the system where police officers were not being held accountable for their actions. Since then, the police board has held public hearings. The police board's effectiveness has varied over the years, frankly, with political appointments under different mayors. But for many years, under the Dailies, the police board was not particularly effective, and frequently there were recommendations made to fire officers, and the police board would not back them up. After the Laquan McDonald killing, that process, that whole procedure at the police board was reformed. So now the police board members, when they get a justified case where an officer has engaged in misconduct, will back up the people who have done the investigation and who have found that the police officer acted inappropriately. The hearings have been public since 1960. The union agreed to that for 40 years. It agreed to it for 40 years because for many years, under the dailies, the police board was known to be very favorable to officers, prejudiced in favor of officers. Now that the system has been evened up so that it's fair to both officers and victims, now the union wants to take it behind closed doors. That is not a good thing to do.
You know, as we mentioned, Jasmine Smith, this is all unfolding as the Chicago Police Department works to comply with the consent decree, which has thus far been somewhat of a slow process, according to the federal judge monitoring it. Do you view the department as having made significant reforms?
No, and it's a reason why it's slow to the process of them honoring and abiding and reporting to the consent decree. It's a machine. And I just want to say that when he say that nothing is factual, it's a fact that Chicago is the #1 capital for wrongful convictions and torture survivors. It's a fact that we are almost $1 billion in on wrongful conviction lawsuits due to police misconduct. It's a fact that the consent decree is not even nowhere near 50% of being answered to or followed by, that the judge presented by CPD. No transparency yet again. The only thing that we're arguing, #1, is that people are innocent in prison. Loved ones have been killed unjustly. These officers that played a role in wrongfully convicting people need to be fired off the force and needs to be charged for the crimes that they committed. We got Brian P. Forberg, Kevin Eberly, John Foster, who was a commander in Area 5. They have lawsuits. They cost the city $3.4 million already. These are factual things that's happening. And he would say that it's frivolous. He would say it's not factual, but the numbers don't lie. The people who have been freed thus far till now, and the people that we are fighting to get freed that's going to come home, is going to show that these cops that's caused a lot of harm, why are they still on the force? Why do they want to have their cases heard behind closed doors if they care about transparency, if they care about public safety? No one is safe if innocent people are rotting in prison and these cops are still on the force that caused that, and the criminals are still roaming our streets. So it's just bad, and it's going to get worse if the judges don't side with transparency, and that's not allowing these cops to have an arbitration in their cases to be heard behind closed doors. If you ain't did nothing wrong, you don't have nothing to hide.
Mm-hmm. I want to ask you about the consent decree. What's your view of that process and its impact on officers' jobs?
Well, the judge, even prior to Judge Dow, prior to Judge Pallmeyer, made it very clear at the beginning of the consent decree they were not going to interfere with anything that violated the collective bargaining rights of the members when it comes in relationship to the consent decree. They weren't just going to do it. They weren't going to violate federal law, labor law, or any law that are protecting those officers. The same argument could be made that we're having this discussion right now. This is an ability under the Public Relations Act in Illinois that affords arbitration as a process to every union member in this state. Why should we be treated any different? And arbitration is a private matter, not a public. The end result does go to a filing with the labor board that can be researched to see what happened. But we keep going back with hashing this. It's a emotional sentiment, it's a factual sentiment. The facts are the facts. These accusations, and I could spend a week on this wrongful conviction stuff. We just had a federal jury basically exonerate 2 officers for nothing wrong because someone was trying to get a quick payday. The city has routinely settled out these lawsuits. That automatically makes the officers guilty. What happened to presumption of innocence? So these offenders, the Wilson brothers, who actually did kill somebody and got basically an innocence certificate by Kim Fox, who cared more about the offenders than the victims, then you give them an innocence certificate, they sue the city gives a payout, and then them law firms who represent those members then give political contributions to the same people who survived to provide the innocence certificate. It's a vicious, dirty cycle.
All right. We just about under a minute left. But
yeah,
yes,
I'll just quickly say, John talks about, what's the difference about police officers that makes them not have to have the same rights and obligations as some of the other union members. Police officers carry guns. Police officers have the ability to decide life and death, and it is incredibly tough and dangerous job, and I personally want to thank all the men and women of the Chicago Police Department who put their lives on the line every day to do that job. But at that same time, because of that ability to decide those decisions, there's a certain responsibility and a level of transparency that I think that they owe to the city of Chicago to make sure that accountability is transparent and public.
And
All right,
change the law in Springfield.
I'm sorry, we're out of time. Lots more to say on this, something we will be revisiting. We thank you all for your time. John Catanzara, Kyle Cooper, David Melton, and Jasmine Smith.
Thank you.
Thank you for being here.
Thank you.
And we're back to wrap things up right after this.
Chicago Tonight is made possible in part by the Alexandra and John Nichols family, the Polk Brothers Foundation, and the support of these donors.
And that's our show for this Monday night. Be sure to sign up for our free email newsletter, The Daily Chicagoan, at WTTW.com/newsletter. And join us tomorrow night at 5:30 and 10. Mayor Brandon Johnson joins us to discuss his decision whether or not to veto the budget that City Council passed over the weekend and over his objections. Now, for all of us here at Chicago Tonight, I'm Nick Blumberg. Thank you for watching. Stay healthy and safe, and have a good night.
Closed captioning is made possible by Robert A. Clifford and Clifford Law Offices, a Chicago personal injury and wrongful death firm that gives back to its community in Chicago and beyond.